Hey all, Valdestot here, and I'm doing this video because I've had a few comments in the past relegating lawsuits. Pretty much on the videos that I put out on the litigation that my lawyer still is investigating on. If you were following my older videos, they're trying to figure out if it's worth doing. We should hopefully get some sort of answer soon on if it's worth proceeding or not. But this is a separate side topic because people have messaged me privately asking, well, what about this scenario? So the title of this is called How to Sue DoorDash, UberEats, or GrubHub. And it's specifically targeted on payment disputes for non-payment for services rendered by drivers. So, for instance, what this means is that if you've done the job delivering food or doing special tasks like going the extra mile or further distances that they promise you that you would get paid but don't, or you do challenges or any sort of extra work on top of your normal deliveries that you would do, and they supposedly are supposed to give you extra payment but don't, what is your recourse? Because you deserve the money that they promised you, and they're either saying, oh no, we don't have record of that, or oh no, that challenge or bonus isn't on the record, and they refuse to pay you. And 99% of the time, drivers will not fight for that money because they're thinking it's just a pain in the ass. What's the point? It's only $50. It's only a couple of $100, especially if it's for on DoorDash. Let's say that you have invite a friend and they supposedly do the challenge, yet the deliveries that they've done in that amount of time is under question. They refuse to pay you. That is what I'm trying to, basically illustrate here. All right. So in the event that litigation is the only recourse that a driver has left, all right, you've exhausted all your options. You've called driver care, customer care, emailed, texted, pleaded, threatened, showed evidence, and nothing is working. And it could be $1 that they're not paying you, or it could be $1,000 they're not paying you. You still have recourse, folks. It's just that most people either don't know about this, don't care about it because it's such a small amount. But if you don't care about it, they win. And they're going to keep doing this to drivers because, you know what? If they screw over 100,000 drivers at $50 a pop, guess what? That's $5 million, okay, that they just saved. So no, we shouldn't let them get away with it. So each of these gig apps has their own system in how you can proceed with a lawsuit. There's small claims court, arbitration, and private settlement agreements. Small claims court varies by state to state. Okay, so you have to follow up after I tell you how to do it with your own state or municipality's rules and costs associated with small claims courts. But if they decide in your favor, you can actually add the court costs and have them pay it because you won. Secondly is arbitration. We'll discuss that later. And third is the private settlement agreements, which they will settle out of court. And normally they're kept private. But those are usually like on higher profile cases or whatnot. But here's the deal. All right, I'll explain each of these. First, we're going to talk about Uber's method. Okay, now First of all, I'm not a lawyer. I'm not a guru. I literally researched this on my own and put this presentation together so you don't have to. But I fully encourage you to as well. Don't take my word for it. Obviously, do your own due diligence to find out the specifics in the states or areas that you are in, okay? Because every municipality and state is different. Case in point, the Prop 22 in California. That's only in California. It's not here in the other 49 states, although they are going to try to put that sort of law nationwide eventually, which is going to suck for us drivers. But that's a different topic for another day. So, Uber. The information I got on the Uber platform is literally, I always give recognition for the information that I get. I'm not claiming it's my own, nor will I ever. I'm not going to plagiarize. So the information I got is from fairshake.com for Uber specifically. And you see the website right there, fairshake.com/Uber/how to sue. All right, so does your case qualify for small claims court? Before you can sue Uber in small claims court, you have to make sure your claim qualifies. There are two things you need to pay attention to: the amount of money. You need to be considerate of the monetary limits that your state places on small claims cases. In most states, it's either $5,000 or $10,000, but it can be as low as $2,500 in Kentucky and Rhode Island. And if you click on that link on their website, you can find a list of all 50 states' monetary limits. Whatever state you're in, find out. 2, the type of relief. You also have to make sure you are asking Uber for the right type of compensation. There are two types of awards that you can seek in a lawsuit. The first is monetary, a dollar value payment, and the second is equitable, any non-monetary request. Most small claims courts can only grant monetary awards, so if you're looking for car replacement parts, for example, they can't grant that. But what they can grant is the monetary equivalent of the value of those car parts, or just a monetary amount. If your claim doesn't fall within the limits of your state's small claims court, you'll have to arbitrate your claim instead. And remember that I did put that as number 2, but that's later. So this is the funny one. Send Uber your demand letter. Here's why I said it's funny. You can't just up and sue Uber without any notice. Okay? I mean, you just can't. Okay? You have to ask them in person to fix the problem voluntarily before you submit your claim. So before you sue Uber, send them a demand letter, okay? I'm going to show you an example of a demand letter so I don't have to read all this, okay? But when you're done writing it, you just need to mail a hard copy of the letter, preferably as certified mail or some other service that allows you to confirm delivery to their legal address. And Uber is legally based in Delaware and receives mail at this address: Uber USA LLC, standing for Limited Liability Corporation. The Corporation Trust Company, Corporation Trust Center, 1209 Orange Street, Wilmington, Delaware, 19801. So, folks, this is a typical small claims demand letter, as you can see. It's got a from, which is going to be you, date, and literally, this is our final attempt to settle this dispute. Dear Uber, you am writing this pretrial letter as a last and final attempt to settle the matter of whatever issue is involved, whether it's non-payment of bonuses, or incorrect pay, etc., right? In the interest of both parties and to settle this matter in an equitable way, we have prepared an offer of whatever the amount is to dismiss this matter. I would add in court costs for small claims court in addition to what that dollar amount is. A response to this letter is required by such and such a date, usually 60 days. If there is no response to this letter, all legal rights shall be explored, including but not limited to legal proceedings in a small claims court necessary to recover the debt without further notice, or this debt may be transferred to a collections agency in accordance with state and federal laws. This offer of settlement serves as an official notice to you and may be tendered in court as evidence of your failure to pay. If legal action is to occur to resolve this matter, it may involve having you pay attorney's fees, which is what I said before, and may impact your credit history. Well, I don't know about that. That's usually for person to person, but yeah. We hope to resolve this matter as soon as possible. Sincerely, your signature. Okay, so that's it. It's pretty simple and straightforward. You don't even need a lawyer to do this. You can do it yourself. That's what I'm trying to get at. So Uber's process is actually, in all honesty, the easiest of the three platforms. So fill out your court forms. Okay, I'm not gonna read all this. You can read it yourself. Okay, just pause it and read it. Um, Obviously, you want evidence to back up everything that you're suing Uber for, because if you go to small claims court, you better have every bit of evidence, screenshots, pay statements for your weekly pay from the app, um, the bonus, if it's a bonus or a quest, what promotion or whatever, right? You better have screenshotted everything, because I'm in this current situation now where they're saying that I don't qualify for a bonus, but I have all the screenshots because I did over 25 deliveries for the week during that period, and they're saying, oh, it's a system glitch. It has been a month since that bonus has been completed. So if they're not going to pay me in the next 2 weeks, I'm going to have to do this myself. So file your complaint with the court, right? You got to file it based on where you're at. They have their own rules, their own specific costs, etc., etc. Okay. Read this on your own, because I'm trying to keep this as short a video as possible. All I'm doing is providing you with the ammo and tools necessary for you to do it. All right. Serve your forms to Uber. Okay, so now is when you tell Uber that you are suing them. This is called a serving Uber. To do this, you need to deliver a copy of your filed papers to Uber. So when you get all the paperwork from the court, from the last section, you're going to basically make copies of it and serve these papers to Uber. Look at your court's website for instructions on how to properly deliver your forms to Uber, etc., etc., etc. Okay. Courts have many strange rules about how to serve a defendant, and your claim will be dropped if you do not follow them perfectly, so be careful. Again, read all this in detail. Go to this website if you have any questions. All right. Lastly, show up for your hearing. You'll be given a court date by the court clerk, and it'll give you a court date after you file your forms. And this is the date of your hearing. You have to go to the right courthouse at the right time with your copy of the filed forms. Bring any evidence you have that backs up your case against Uber. Sometimes Uber will not show up to oppose you. If that happens, take advantage of the situation to focus on your side of the story. And chances are, if it's under a certain dollar amount, they're not going to show up. I mean, it costs them more in attorney's fees on their side to send an attorney than to fight for 50 bucks, 100 bucks, $1,000. It's just not worth it sometimes. So 90% of the time, it's an automatic win on your side. They're just hoping people don't go to this extent. That's what they're banking on, folks. But if everyone does this, guess what? Change is eventually going to happen, because they're going to say, oh crap, we're getting a lot of litigation here for scamming our drivers. I guess we may not want to scam our drivers in the future. That's the whole point, folks. All right, so GrubHub. This one's going to be a shorter one, because I don't know if the contract agreement has changed since they merged with Just Eat's Takeaway, since they bought them out, or if it's still the same, because I could find very little information after 2020. So this is what I mean. The GrubHub delivery partner terms of use. Look at the date on that. This is the latest one I could find online, and it's dated January 16th, 2020. Every driver gets this partner terms of use before we can. If we log onto the platform, they're going to assume when the newest one comes in, you read it And once you take your first order, you have automatically agreed to the terms of service. Shady as hell, I know, but that's how all the platforms do it. So this is what I mean. I didn't screenshot everything for this because there was just no need. I got to the meat and potatoes. And get this, folks, this is really a blanket one. One small paragraph is all they had. Uber and DoorDash had a ton more than this thing. This is just a general indemnification clause from GrubHub. The driver agrees to indemnify and hold harmless the released parties from all claims, actions, losses, judgments, liabilities, damages, costs, and expenses, including reasonable attorney's fees, arising out of your breach or alleged breach of any provision of this agreement. Your violation of applicable law, your use of the driver app and or materials, including without limitation all diner data and all uses of your user content by GrubHub or any third party authorized by GrubHub. That's it. That's the only thing they put down in the entire GrubHub partner agreement. It doesn't have arbitration. It doesn't have none of that. I was like reading all this and I'm thinking, dang, this is something general. And I had to find out exactly if there were ways around this or what the actual textbook definition of indemnification is. So here's my analysis on this. The definition of an indemnity agreement. Okay. 1. An indemnity agreement is a contract that holds a business or company harmless for any burden, loss, or damage. An indemnity agreement also ensures proper compensation is available for such loss or damage. So 2. The parties of an indemnity agreement. In the case of gig work, these would be the parties involved in an indemnity agreement. 1. The indemnity, that's a mouthful, is the word who is protected from any liability. This will be the GrubHub company. The indemnifier is the one who promises to reimburse the indemnity for any claims. This would be you, the independent contractor or driver. 3. You would sign an indemnity agreement with the gig app GrubHub company. By signing the indemnity agreement, protects the gig app GrubHub company against any lawsuits. 4. A driver would have to find an attorney specializing in business litigation to sue GrubHub directly for the loss of pay due to GrubHub not paying you the correct amount for any reason. These reasons could be underpaying you based on individual deliveries. Driver care agent stating additional pay will be given for added mileage to a diner, which never happens. Bonuses for X number of deliveries in a specified time frame that were not given to you. Drivers must have irrefutable evidence that GrubHub did not make good on payment either with screenshots of orders, recordings of conversations to driver care representatives, or other such evidence to proceed. Literally, without any sort of arbitration that DoorDash or Uber provides, you literally, based on the lack of clarification other than just a standard hold harmless indemnity agreement that GrubHub uses, you literally have to either get a lawyer or hope that a small claims would be sufficient, although I'm not 100% sure on that. Again, I'm not a lawyer, but yeah, you literally are on your own on this to fight for money. Now, again, you can always tack on attorney's fees on top of the missing money, okay? And again, 9 times out of 10, drivers do not pursue losing anything under $500. They're thinking it's just too much work. This is the reason that these companies make it so difficult for you to recoup your losses based on their shadiness or their tech failing to record these payments, or driver care, driver care basically just saying, oh yeah, we'll give you an extra $5 if you go those 3 extra miles, and never get the payment. They don't expect drivers to fight for it. I'm giving you information so that you have at least the information to be able to hold them accountable. Whether you drivers do it or not, that's not on me, okay? But unless we stand together to do it together, no change is going to happen. They're going to keep doing it. All right. So, lastly, DoorDash. Okay, folks. This one is the biggie, and I saved it for last, okay? Because they have a couple of pages of, no, I think 2.5 to 3 pages of this, okay? And I just basically just copied it and whatnot. Now, when I say 2 to 3 pages of it, that's the actual page size, but because I had to copy and paste it, there's more than that because it's not the full size of the pages. So bear with me, all right? So I'm not going to read all this. I'm only going to read the pertinent information, okay? So with DoorDash, you have to go through a mutual arbitration, all right? You can't just outright sue them, kind of like Uber, all right? But you can't just go to small claims court like Uber either, all right? I'm going to skip ahead to right here. Number 2, right? Well, if number 1 is contractor and DoorDash mutually agree to this mutual arbitration provision, right? And it goes from there. 2, contractor and DoorDash agree that good faith informal efforts to resolve disputes often can result in a prompt, low cost, and mutually beneficial outcome. Mutually beneficial, yeah, it's more like one-sided, to be honest, but let's go on. Contractor and DoorDash therefore agree that before either contractor or DoorDash demands arbitration against the other, we will personally meet and confer via telephone or video conference in a good faith effort to resolve informally any claim covered by this mutual arbitration agreement. If contractor is represented by counsel, a lawyer, contractor's counsel may participate in the conference, but contractor shall also fully participate in the conference, namely the driver. The party initiating the claim must give notice to the other party in writing of their intent to initiate an informal dispute resolution conference, which shall occur within 60 days after the other party receives such notice, unless an extension is mutually agreed upon by the parties. To notify DoorDash that contractor intends to initiate an informal dispute resolution conference, email, and I highlight it here for you, dasher.informal.resolution@doordash.com, providing contractor's name, the telephone number associated with contractor's Dasher account, if any, the email address associated with contractor's Dasher account, and a description of contractor's claim. In the interval between the party receiving such notice and the informal dispute resolution conference, the party shall be free to attempt to resolve the initiating party's claim. Engaging in an informal dispute resolution conference is a requirement that must be fulfilled before commencing arbitration. The statute of limitations and any filing fee deadline shall be tolled while the parties engage in the informal dispute resolution process required by this paragraph. So I'll read the next one too. If following the informal resolution process, either contractor or DoorDash wishes to initiate arbitration, the initiating party must notify the other party in writing via certified mail, return receipt requested, or hand delivery within the applicable statute of limitations period. This demand for arbitration must include 1, the name and address of the party seeking arbitration, 2, a statement of the legal and factual basis of the claim, and 3, a description of the remedy sought, and 4, the amount in controversy. Any demand for arbitration by contractor must be delivered to the counsel who represented DoorDash in the informal resolution process, or if there was no such counsel, then to general counsel at 303 2nd Street, Suite 800, San Francisco, California 94107. So, and of course, we waive the right to arbitrate class action. Okay, so I mean that's basically it. So this is the main points that I wanted to bring to you before I go on to the next pages. Okay. In a nutshell, they want you to try to hash it out in private with one of their counsel before any real arbitration begins. Hopefully that anything that is stated at this preliminary point in time, they will resolve. If it can't be resolved at that informal setting, then you have to go through the whole steps to get to the formal arbitration process. And in the meantime, it's stated that you're going to start getting charged tolls, which is like the costs of doing this, okay? Even in the informal process. I mean, they really don't want you to proceed forward. So therefore, they are literally saying, well, if you want to pay, you're going to play. If you want to play, you're going to pay. That is how this works, folks. I mean, literally, they are trying to make it as hard as possible to do anything. It's sad, but what can you do? So, moving on, you can read these rules. It's in your contractor agreement through DoorDash. This is the second page. And here's one of the things I wanted to tell you about, okay? Now, I know a lot of drivers don't even read the contract. They just say, okay, TLDR, too long, didn't read, or TLDC, too long, didn't care, okay? But realistically, folks, you are signing away a lot of your rights by not doing this, by not reading about it, okay? Number 9, contractors' right to opt out of mutual arbitration provision. Arbitration is not a mandatory condition of contractors' contractual relationship with DoorDash, and therefore contractor may submit a statement notifying DoorDash that contractor wishes to opt out and not be subject to this mutual arbitration provision. In order to opt out, contractor must notify DoorDash in writing of contractor's intention to opt out by sending a letter by first-class mail to General Counsel at 303 2nd Street, Suite 800, San Francisco, California 94107. Any attempt to opt out by email will be ineffective. They're making it very hard. The letter must state contractor's intention to opt out. In order to be effective, contractor's opt-out letter must be postmarked within 30 days of the effective date of this agreement. The letter must be signed by contractor themselves and not by any agent or representative of contractor. This letter may opt out at most only one contractor, and letters that purport to opt out multiple contractors will not be effective as to any. No contractor or their agent may effectuate an opt-out or on behalf of other contractors. If at the time of contractor's receipt of this agreement, contractor was bound by an existing arbitration agreement with DoorDash, that arbitration agreement will continue to apply to any pending litigation, even if contractor opts out of this arbitration agreement. If contractor opts out as provided in this paragraph, contractor will not be subject to any adverse action from DoorDash as a consequence of that decision, and they may pursue available legal remedies without regard to this mutual arbitration provision. Therefore, you can sue them on your own without having to go through arbitration through a private attorney. If contractor does not opt out within 30 days of the effective date of this agreement, contractor and DoorDash shall be deemed to have agreed to this mutual arbitration provision. Contractor has the right to consult with counsel of contractor's choice concerning this mutual arbitration provision or any other provision of this agreement. So, pretty much, if you do not, as soon as the new terms of agreement contract from DoorDash comes out from that date, you have 30 days to do it. Literally. Now, I'm not 100% sure about new Dashers that basically come in after the 30-day release of that contract, if you can opt out, because it literally says right here, if contractor does not opt out within 30 days of the effective date of this agreement, effective date of the agreement could be, let's say, January 1. And let's say that it takes 6 months before they put out a new agreement, and you come in as a new Dasher in March. I'm not sure if you can opt out of the agreement. You can try, but based on the wording of it, I don't think you can. But I could be wrong, okay? Again, I'm just providing what the information states. And of course, the biggie, litigation class action waiver, we can't do it in not so many words, okay? So If you're still here, we're going on almost 30 minutes now. You know, I like to keep my videos in around 30 minutes. Still amazed at how difficult it is to sue these companies? You aren't the only one. The legal system is designed to deter regular people like you or me from suing corporations. They have teams of attorneys that make it so one-sided when we sign contracts or don't sign contracts. Remember, taking that first order automatically means that you've read the agreement and you are agreeing to it, okay? So it's so one-sided when we sign contracts that drivers literally have no recourse without help from other attorneys. And the corporate attorneys that they hire, Doordash, GrubHub, UberEats, are typically the ones from the best schools. It pays to be wealthy in America. It pays to be a corporate business. Unless you have an ironclad case, this is number 2, against these companies with mountains of evidence, the chances of any attorney willing to represent you are slim to none. There are some attorneys willing to take cases against corporations, but they are usually trying to make names for themselves, or the evidence is so, ridiculously on your side that it's a surefire win. Because remember, attorneys don't want to take cases that they're going to lose at, or take cases that doesn't make sense for them to take, like there's no money in it for them, or there's just going to be so much work that's going to cost them so much money, and they're going to obviously charge us drivers that the cost that they're going to do to mount the case, right? And these types of cases are usually not pro bono. That means that you don't pay unless they win. Okay? These cases are never that. So what to do? Don't give up your rights to get your money. If you have the evidence and proof, contact an attorney or go through the steps of arbitration or send a small claims demand letter as stated earlier. 2, depending on the platform involved, you will have to use their method of mediation and unfortunately their rules. But that doesn't mean that you won't win, especially if you are in the right and have evidence to back it up. Always screenshot text messages involving bonuses, incentives, extra pay, along with your weekly pay summaries. Also, record all conversations regarding pay from support representatives. Okay? This is literally the end of the video, folks. All right? All I'm doing is giving you ammunition and information so that you don't get screwed in getting underpaid or pay that you deserve. It is up to you and every driver to fight for your rights, fight for your pay. I can only provide the information. I can't make you do it. But if we do this together, folks, if everyone does it, change will happen, because they're going to give up and spend millions of dollars in litigation costs on their side because their attorneys are literally just contracted to be with them. Okay? They have to pay their attorneys on retainer. And that means that anytime they have to litigate, they get paid. So if thousands of us or hundreds of thousands of us start litigating, I don't think they want to spend millions upon millions of dollars paying lawyers' fees and court costs. Then this forces them to change their MO and make sure that they do the right thing by paying us what we deserve when we complete certain things, like the bonuses, the incentives, the inviting friends, not paying less than the order screenshots that we provide, that when we get those offers, that sort of stuff. So folks, this is the end of the video. I'm going to leave it here. Thank you all for sticking with it, and hopefully I provided you with the information to make informed decisions on litigating and suing these companies if you don't get your money. Have a great day, all, and I'll see you next time.